Welcome to The Dad Lawyer, a program produced by the Parents Estate Planning Law Firm in conjunction with ActonTV. I'm your host, David Feakes, founder of the Parents Estate Planning Law Firm in Acton. We help parents protect the people that they love the most. The Dad Lawyer is a program for parents with young children dedicated to highlighting the legal and financial issues that are specific to parents and growing families in Acton and the surrounding communities. I've been an attorney for 27 years, but I've also been a dad for 20, and balancing both titles means a lot to me. I started my own practice years ago because my oldest daughter was then still a young baby. She's almost 20 years old now. And so I know a lot about being a lawyer, and I know a lot about being a dad. But what my wife and I realized as we became parents and as owners of our law firm is that there's a lot more to legal planning for parents with young kids. And so we've really come to focus on the legal needs of growing families and families with young children. And we recognized in our own planning that there were potential gaps in the plan that we had created for ourselves, because most traditional estate planning lawyers don't really focus on the needs of growing families. And so once we figured out how to solve the gaps in our own plan, we knew that we had to create those airtight plans for our own clients, and more importantly, we needed to get out into the community and educate families on the kinds of legal issues that face them and the things that they need to know to make sure that their kids and their families are very well protected in the future, no matter what. So this is our first episode, and I wanted to start off in today's episode really just beginning to review the foundational 5 documents that should be part of every growing family's estate plan. And the first of those documents, or the first set of documents that every parent really should have in place, especially when you have young kids, is what we would call a kids protection plan. And that basically means naming guardians for your kids. But a kids protection plan is more than just about naming guardians for your kids. It's making sure that there will be people there and ready for your kids all along the way if anything ever happens to you as parents. And most people think of guardianship in terms of long-term guardians. In other words, if we were both to die, who would we want to step in and care for and love and raise our kids if something happened to both of us until our kids had all turned 18, which is when they no longer need a formal legal guardian. But kids protection planning is about more than just naming long-term guardians. Yes, long-term guardians are important, but there's another element of guardianship planning that is just as important, and in many cases it's even critically important, and that's short-term planning. And that's the piece I want to start on today. Short-term guardianship planning is really all about making sure that there are people in place who can fill the potential gap between the time something happens to you and the time when your long-term guardians can arrive and take over the care of your kids. So short-term guardians would look like people, they would be your neighbors, and they would be your friends, and they might be family members if you have family members who live close by to where you live. But we generally recommend that you should have a group of people that are within 15 or 20 minutes of where you live, who you know and trust, who your kids know and trust, who can come over and be with your kids on a short-term basis. Then the long-term guardians are the people that you know and trust to raise your kids as close to the way that you would if you were still there. And again, those might be family members, but you shouldn't always limit yourself to family members, because sometimes friends might be the best candidates to become long-term guardians for your kids. Whoever it is, you want to and need to identify who those people are and to document those people legally. It's not enough to have the conversations. It's not enough to write it down on a scrap piece of paper if you're traveling away from your kids for the very first time. You need and want to legally document all of that. So a kids protection plan includes short-term guardians, long-term guardians, and then we strongly recommend that for the people who are caring for your kids, maybe it's a babysitter, maybe it's a daycare provider, but whoever your caregiver is when you have young children, that those people should have a set of instructions on what to do if there is ever an emergency. So those people should have your cell phone numbers. Those people should know who your short-term guardians are, and they should have the telephone numbers of those short-term guardians. And then equally, we would recommend that each parent carry in their purse or wallet what we call a family emergency ID card. And that would identify each other as a contact person, and it would identify the rest of your short-term guardians as people that emergency responders can contact in the event something were to happen to you. So say, for example, you were in a car accident and you were carrying a family emergency ID card in your wallet. As emergency responders were helping you, they would likely find that card in your wallet. They would know that you had young kids at home, and they could either be calling your spouse, if you're married, who would naturally be the first person on your card, or if you and your spouse were together, they could be calling the friends and neighbors, the people you had listed as your short-term guardians, and those people could be notified to go over to your house and to take care of your kids. And by the way, caregiver instructions, what we also call babysitter instructions, and ID cards aren't just when you have really young kids. If you have teenagers at home, but they're under the age of 18 and they're just taking care of themselves, I have a 16-year-old at home. She's home alone a lot of the time. But because my wife and I have this planning in place, my 16-year-old knows exactly what to do if for some reason my wife and I don't come home when we say we're supposed to, or if my daughter can't reach us on her cell phones. So if you have teenagers at home who aren't yet 18, aren't yet legal adults, that those instructions and that planning would be in place to let them know exactly what to do in an emergency. So that's the first set of documents that every parent should have. The next set of documents that every parent should have is a will. And most people know conceptually what a will is. A will does two very important things for parents with young kids. The thing that most people think of wills as doing is creating a set of instructions about what should happen to your assets, to your bank accounts, to your house, to your investment accounts, to all of your assets if you were to die. And that is primarily what a will is. The second function of a will is to name long-term guardians for your kids in the event you were to die. So in a will, you would leave a set of instructions as to what should happen to your assets, and you would identify the people you want to be the long-term guardians of your kids. So wills are critical documents, especially for the guardianship piece, if you have kids under the age of 18. Now again, a will is not something you write on a scrap of paper. A will is something that you do formally. It has to be signed formally. It requires witnesses in Massachusetts. It should be notarized. So this is not something that necessarily you can easily do at home. It's really something that you should be talking to a professional about. But that is the second critical document that every parent with young kids should and must have in place. The third document that most parents should have in place is what we would call a revocable living trust. And in many ways, a trust becomes a will substitute. And we often refer to a trust as a will substitute, in the sense that with a trust in place, you would be taking the instructions about what should happen to all of your assets, and you would be moving those instructions into your revocable living trust. And then your trust would become the document that has all the instructions about what should happen to your assets. The trust would also have instructions about who should take over the management of your assets if something happens to you. Now, we don't put long-term guardian nominations in a trust. We still have to have a will in place to do that. So the trust only becomes a will substitute as to your assets. But a trust has a lot of benefits over just having a will. For example, with just a will in place, all of the assets that you owned in your own name, which for most people is all of their assets, that would be their house and their bank accounts and their investment accounts. With a will in place, all of those assets are going through a mandated court process we call probate. So if you have at least $25,000 worth of assets, your assets are going through a time-consuming, cumbersome, and in many cases expensive court process. And so when we present that to parents with young kids, especially for parents with young kids, most of them would say, I don't want my family to have to deal with a time-consuming, cumbersome, expensive court process. Is there a way that we can make things as easy as possible for our guardians and for our families and really for our kids? And the answer is yes. You can avoid that probate court process. The way to do that is by creating a revocable living trust. And then you need to own your assets in the name of that trust. When you have the trust set up, and when you're owning those assets in the name of the trust assets don't have to go through probate. So now you can save your family that court administration process that assets would otherwise have to go through. The court is still necessary to approve long-term guardians for your kids, but with a trust in place and with assets owned in the name of the trust, your family wouldn't have to deal with that probate court process. So a trust, for most families with young kids, becomes a very critical part of the planning. For example, about 95% of the clients that I see in my office create trust-based plans. And it's always because once they understand what that court process is going to look like, they know they don't want their family to have to go through that process. So the next document that's critical for every parent, and this is not just for parents with kids under the age of 18, this is for everybody 18 years of age or older, and that is to have disability documents in place. So the first of those disability documents, or the first grouping of documents around disability or incapacity, would be what we call a healthcare proxy in Massachusetts. A healthcare proxy is a document in which you give other people the legal authority to make healthcare decisions for you if you can't make those decisions for yourself. If you're incapacitated, if you are not able, if you're unconscious, if you're not able to make decisions for yourself, or if you're not able to communicate those decisions, a healthcare proxy comes into play. And again, it's your appointment of other people to make those decisions for you. Together with a healthcare proxy, we always want our clients to have what we call a HIPAA waiver or a HIPAA authorization. So most people understand that there is a medical privacy law. It's called the Health Insurance Portability and Accountability Act. And basically what that federal law says is that your private personal medical information cannot be shared with anyone else without your express written consent. So what can often happen is that if you need people to make decisions for you, and even if you've appointed other people to make decisions, medical decisions for you, they can run into inadvertent roadblocks in the form of HIPAA. So they might not be able to get all of the medical records or medical information that they might need to make informed and intelligent decisions on your behalf, because HIPAA says your personal medical information is prevented from disclosure to those kinds of people. So what we have our clients do is sign what we call a HIPAA waiver or a HIPAA authorization, which gives the people they've named in their healthcare proxy the power to access all of that medical information, to be able to access their medical records, to be able to freely communicate with healthcare providers about the kind of care that is necessary. So that's important as well. And then the third document that we add into the healthcare grouping of documents is what we call a living will. And that's a document that basically says, if you are ever in a persistent vegetative state, you want to leave a set of instructions for your healthcare decision makers about how you would want them to make decisions surrounding life-sustaining procedures. So it might be, if I'm not going to recover a meaningful quality of life, I don't want to be kept alive artificially. Or it may be that I do want to be kept alive for a certain period of time. Whatever your wish is, it's a way to pull those wishes together into a document that expresses everything to your healthcare decision makers so that they are not left wondering what it is that you would want to have happen under those circumstances. And then the final document of our five must-have legal documents is also in the incapacity segment, and it's what we call a durable power of attorney. Now, a healthcare proxy deals with healthcare decision-making. A durable power of attorney deals with legal and financial decision-making. So again, if you were ever incapacitated and not able to make legal or financial decisions for yourself, a durable power of attorney is a document that would allow other people that you have appointed to make those decisions for you, to take those actions on your behalf, and to have access to everything that they would need legally or financially to take care of you legally or financially. For example, if you own a house and you were incapacitated and the house needed to be sold, you wouldn't be able to sign a deed. And until you're able to sign a deed, the house can't actually be legally transferred. So with a durable power of attorney in place, your agent, the person who has the power under your durable power of attorney, would be able to sign a deed on your behalf, and the transfer of the house could be completed. Tax returns. A durable power of attorney would allow someone to sign a tax return on your behalf if you were not able to do that on your own. It would allow somebody to be able to have access to your financial accounts, to make allocation decisions on things like a 401k or an IRA. Even really simple things like going to the post office and signing for a certified mail or a registered letter. A power of attorney can do that. And so that's why that is a critical document as well. So those are the 5 must-have documents for every parent who has a child under the age of 18. Wills, kids protection plan, long-term and short-term guardians, trust if you want to keep your family out of that probate court process, healthcare proxies, HIPAA waivers, living wills, and a durable power of attorney. Now, a point for those of you who have kids who are 18 years of age or older, those incapacity documents are just as important for your children who are turning 18. Because here's the thing, once your kids turn 18, they become legal adults. And if any of you out there have kids who are about to turn 18, I discovered this when my daughter turned 18, suddenly you're not able to make decisions for them anymore. And suddenly you're not able to access information that you were always able to get about your kids when they were 17. So once your kids turn 18, they need their own incapacity documents. They need their own healthcare proxy. They need their own HIPAA authorization, and they need their own durable power of attorney. So when your kids go off to college, for example, if they're ever injured while they're at college, the healthcare center, the infirmary, they might not be able to share information with you because of the federal medical privacy law, HIPAA. But if your kids have signed documents before they go off to college, then they can give you the ability and the authority to not only make decisions for them, but to gain access to the information that they would need to make decisions on their behalf. So we recommend that every kid going off to college, indeed every person 18 years of age or older, should have a healthcare proxy, should have a HIPAA waiver, and should have a durable power of attorney as well. Not just for parents with young kids, but it's for your kids once they grow up and become adults as well. So those are the 5 must-have documents. The other thing I wanted to talk about in this first segment of The Dad Lawyer is really 12 questions that you can be asking an estate planning attorney if you're going to interview someone or meet someone for the very first time, if this is the first time you've been getting estate planning in place for yourself. And the very first question that you should always ask an estate planning attorney is, especially when you're the parents of young kids, is, can you prepare a kids protection plan for me? Or the functional equivalent of a kids protection plan. Can you name long-term guardians for my kids? Can you name short-term guardians for your kids? You want to make sure that any estate planning attorney that you're talking to, if you've got young kids, knows what short-term guardians are, because not every attorney does. You want to make sure that they can create things like caregiver instructions for you, and you want to make sure that they can create an emergency ID card for you that you can carry around in your purse or wallet. You want to make sure that the estate planning attorney that you're thinking about working with is going to operate on a flat fee basis. Estate planning is something that you should expect to pay a flat fee for. You don't need to pay hourly for this. You really shouldn't be paying hourly for this. The problem with hourly billing, here's the thing, lawyers love hourly billing because they get paid for their time. However much time they put into the matter, they get paid for it. But the downside of hourly billing is for you, because you never know right up front what the potential cost of something is going to be. And that makes it hard for you to make informed and intelligent decisions about whether a planning level is right for you, or how much planning do I need, or is this right for me versus that right for me. That becomes much easier for you if everything's done on a flat fee basis. You should be able to know right up front what the potential cost of your planning is going to be. Now, it might not be down to the penny. You might get a range of fees, but that range should be dependent upon decisions that you make so that you have control over it, but it will give you a sense of how much things are going to cost, and that will allow you to make informed and intelligent decisions about how much planning is right for you and what level of planning is right for you. The third thing you want to be sure of is that the attorney that you're talking to has a team in place to support you. You really are not going to be served well if you're dealing with a solo attorney, because you don't know how many clients they can handle. You don't know what's going to happen if they get overwhelmed by the number of clients that they're handling. And so you want to make sure that the attorney has a team to support not only them, but a team to support you as well. The fourth thing you want to ask a potential estate planning attorney is, what happens if I have a quick question? How am I going to get a quick question answered? In our office, anybody on our team can answer quick questions. They know most of the answers to the quick questions, and let's face it, it's because we get the same questions over and over again a lot of the time, so they know the answers. What they know is that if they don't have a quick answer, or really they don't have an immediate answer, they will find out when's a good time to get back to the client, and they'll get back to you for an answer. But all of my clients know if there's something more legal or strategic, that I'm always available to answer those kinds of questions, because those are the kinds of questions that the team members can't answer. Support staff can't answer legal questions, and they can't give legal opinions, they cannot offer legal advice, and they can't really give strategic advice. So our clients know that they can reach out to me for a scheduled call to get those answers. But anybody you're talking to should have a team in place that can answer those quick questions, or at least a way to get those questions answered. You want to make sure that if you're going to have a trust in place, that the lawyer is going to help you to get those, the assets that go into the trust titled in the name of the trust or transferred into the name of the trust in the right way. And there's only two ways that that can happen. Either you're going to do the retitling of assets yourself, or the lawyer's going to do the retitling of the assets for you. Either way, they should be providing you some level of support. Even if you're doing the titling of assets yourself, the lawyer should be giving you some kind of support documents that kind of give you instructions about what you need to do and how you need to go about doing it. In our office, we give our clients a funding toolkit when they do their own titling. But we also offer our clients the opportunity to have us do the work for them. And for some of our clients, that's really important. They want to know that that work is getting done correctly and that that's taken off their plate. The next thing that's important for you to ask a lawyer is, what happens if things change in my life? I want to have a way to get changes in place in my plan. And so they should have a way that you can get those changes made. You want to make sure that there's some kind of ongoing maintenance program or membership program potentially, so that changes that happen to you in the future, those changes can be made easily and seamlessly. What we do in our office is not so much have a membership or a maintenance program, but what we really have is what we call client review meetings that happen on a fairly regular basis. So our clients know that they're going to be coming back in on a regular basis to get updates in place and just to ask questions. You want to make sure that your lawyer can tell you that if you have young kids, that they know how to structure your plan so that the assets you leave to your kids will be protected in the future against all kinds of third parties that may exist in your kids' lives. Let's face it, your kids are going to grow up someday, they are going to become adults, and when they become adults, we don't know what's going to happen to them. You don't know what's going to happen to them. They may have creditor issues, they may get sued at some point in their lives, they may get married and divorced, and you want to make sure that your lawyer has a way for you to set up your trust so that your kids can be protected from creditor, so that the assets that you leave to them really can be protected from creditor claims or potential lawsuits, or potentially from the claims of a future divorcing spouse. You want to make sure that your estate planning lawyer will in some way guarantee that the service that they're providing to you. You want to make sure that if you need to change things after you sign your documents because you didn't make the right decision the first time around, that your lawyer is going to give you a period of time to do that. In our office, we give our clients 90 days to make changes to their plan, because we recognize we ask them to make decisions on a fairly quick basis. And then finally, you want to make sure that the lawyer you're talking to is not just there to answer the legal questions, but is really there to guide you on things like buying life insurance, on saving for retirement, on saving for your kids' college education. So for me, in our office, that's not something that I'm an expert on. I'm an expert on the legal stuff, but I know people who are experts on all of those things. And so I'm available and ready to refer everybody to the right person, the person I know is going to take really good care of our clients, who are experts on things like life insurance and saving for retirement and saving for college through, say, a kid's 529 plan. So those are all of the questions you want to make sure that you're asking a potential estate planning attorney so that you know that you're dealing with the right person. So I want to thank you for joining me on this edition of The Dad Lawyer. It was our first episode. I enjoyed bringing all this information to you. I hope you'll join us again next month. If you have any questions at all about anything that you've learned today or any of the information that we've shared today, if that's resonated with you but you have questions, please feel free to contact our office for further resources. You can reach our office by phone at 978-263-6900, 978-263-6900. You can visit our website, www.parentsestate-planning.com, for additional articles and information about legal and financial challenges facing parents of growing families. You can visit www.thedadlawyer.com, www.thedadlawyer.com. Thanks again for joining me, and I'll see you again next time.